Possibly. So the standard form that's used in the state of Florida has been approved by the Florida Bar and the Florida Association of Realtors. So the FAR Bar contract is what it's called. And in that contract, as with the many other types of contracts, there is a provision called force majeure. And basically what that refers to, most people may not recognize that term, but they will recognize the term acts of God. So you have certain things that neither side can predict, and based upon that, it may be an excuse not to perform obligations under the contract. Now there has to be some type of nexus between the actual act of God, so to speak, and the obligation that you are unable to fulfill. And it also depends on the other party, how willing they are, if they're going to fight that issue or not. Typically speaking, before the coronavirus pandemic, the force majeure was usually tied into something where you didn't have the ability to close by the closing date. So if you were to miss a flight, or if something happened in an emergency circumstance and you weren't able to get to the location and you couldn't close remotely for whatever reason, and you couldn't perform because there was a closing date, then a lot of times that type of defense would be upheld, but you would have to try and comply with the terms of the contract aside from the closing date. In other words, if you couldn't close within a week or for a week after the closing date, and then you were able to, and you made a good faith effort to do so, and you couldn't close for some other reason, or the contract backed out, or the other party said, well, wait a second, no, if you can't close by this date, then the contract's off, we're not going to give you another week, and we're going to keep your deposit, and we're going to sue you for specific performance of the contract. So a lot of times that's what would happen prior to the virus spreading so much. But now there are so many economic factors and logistic factors to actually close on a piece of property that term is being used much more broadly. What the courts are going to do with it, who knows, because it's been so recent that these cases have not reached judges, and in fact the court systems are pretty much, at least in Florida, closed down with the exception of essential criminal cases and phone hearings on a lot of civil cases. That may change, in a while, depending on what the numbers are and what the government decides to do with it, and the Supreme Court in the state of Florida and the governor's office. But at this point, you basically have a kind of a new frontier when it comes to case law and how judges are going to handle breaches of contract. So that's a very long answer to a short question, and to kind of summarize it, it kind of depends. It depends on the reason for claiming that you can't perform on the contract, whether you're the seller or the buyer. B, what kind of mitigation you did to try and salvage the contract. And C, what the judges are going to do with this and how broadly they're going to interpret the force majeure terms within a real estate contract.